On today's podcast of Data for All, responsible data. Welcome to the Data for All podcast. I'm Charlie Apigian.
And I'm Charlie Yielding, where we want to empower you to think different with data.
And on today's podcast, we are going to focus on AI, data, and what is being done to ensure that we're using it responsibly.
Well, but before we get to that and our guests and whatnot, we want to thank the Nashville Technology Council for letting us use their wonderful premises to record our wonderful podcast.
Yes, and it's our second time in here. Hopefully we're getting some of the bugs out, still playing with things. But the great thing about today is what, as we were talking, we get a lot of people talking to us about responsible AI. And what we were most interested in is not just AI, but also just responsible data in general, with privacy, with everything. And Charlie, I said, I've got one guy I know that we should have on. And because of his what we found out is his podcasting career, as well as his knowledge in this space. So Franklin Graves, thank you so much for being here.
Thank you both for having me. Yeah, and I will say, it's nice to hear that intro music at the right speed, because when I'm normally listening, it's like on 1.5x, and it's like, oh, that's a banger if I just like slow it down a little bit.
So does my voice sound different because it's normal
always.
Sound, and then it's one of those things when it's on normal speed, and so when I hear my voice on 1.3 is what I do. I'm like, boy, why am I talking so fast? Why am I doing that? And then I realize, I got to go back to 1 speed if I'm listening to me.
Yeah, so I can listen to myself at normal speed and 1.5. Anything else is rough for me.
1.5, just over that, I can't understand. I can't keep up mentally. Like, I just can't handle it. But
Well, for today, we brought you in not just because of your podcasting chops, but because you are a lawyer.
But I'm not your lawyer if you're listening.
No.
That's right. And you're here today as a knowledgeable person in AI. That's why we have you on here today. But Franklin, why don't you go ahead and tell us who you are? And a little bit, we always ask about a data journey. So we're going to force you to talk about your data journey as well.
Yeah, thank you. So as you said, I'm an attorney. I work for a large healthcare company here in town in Nashville. But outside of that, I'm also an adjunct professor. I do a lot of blogging and creator economy work, working pro bono, which means like low service or no fee legal services with YouTubers, focus specifically on what are called edutubers, so people that are creating educational content, like podcasters.
Hey, I know those folks.
and getting them like answering legal need questions and providing education. That's the biggest thing. Is like the more educated you become in this space, the better you can protect your brand, your business, and all that going forward. So that's what I love to do on the side. I love to blog about it, write about it, and that's kind of what got me going down this path. But yeah, full time, I am a technology attorney. Focus only really on technology. AI, of course, is everywhere now. Data has always been a key aspect of that as well for a long time. But yeah, I love listening to everyone on the podcast talk about like their data journey. So for me, it even goes back to like when I was in middle school. I grew up as a child of the internet, Napster, Kazaa, LimeWire, all that kind of fun stuff. So for me, music metadata became one of the first touch points I had to understanding the importance of data management. And so like whether it was like having a very clean looking iTunes library before you could go and buy it, or a Winamp, have it load metadata correctly on there. Stuff like that I was always into.
Oh, hang on.
Yeah.
So would you go replace the cover art if it was incorrect?
Oh my gosh, absolutely.
Me too.
Because sometimes it would pull from the database and I would be like, no, that's not clear enough, that's not good enough, or I want an alternate cover, stuff like that. Oh yeah, all the time.
I just loved it when Windows would display my record appropriately once I started collecting digital music.
Yes.
So my first pod, it wasn't an iPod. It was a MP3 player, was a Philips one. It was this little round thing. And yes, everything came on there. And sometimes it would be like off by one song. And so I'd have to go in and fix things on my Windows 95 computer. And then I felt like it was still going to skip. Of course, I did have the CD Walkman. And of course I had Walkmans. So you talk about you're part of the internet world. As a kid, I hate hearing that kind of stuff.
Well, no. So to be fair, I did have tapes. I would record songs off the radio when I was in elementary school, make my own mixtapes, do stuff like that. But yeah, by the time I was in like middle school, early high school, it was burning your own CDs,
Yeah.
buying CDs and ripping them so you had them digitally, things like that. And a lot of that got me interested in understanding data, where data's come from, what is Grace Note in the music industry, things like that, or Nielsen now, I guess. But yeah, it's kind of fun to think about it from an early digital age of what data meant. And so for me, that was a lot of it.
That's
Gotcha.
awesome.
So before we get into the fancy topics, because I know that Charlie loves this topic of data privacy, and I'm going to let him run that show. But I'm interested in you as a lawyer. Where are you seeing data or AI really starting to affect, or what is it that you do from a data perspective that is delightful and joyful for you in your job?
Yeah, so delightful and joyful for me and my job.
Well,
With
data is always
Pro bono,
delightful and
all that type
joyful.
of stuff.
Yeah.
So I think data can mean a lot of different things, obviously. I mean, you talk about that on your podcast a lot. So access to information, that's data. So having access to contract information, negotiation, even in like the creator space, understanding what other creators are getting paid for their brand deals, having transparency, because a lot of times like in the creator space, there's not one union, there's not one agency or group that represents creators. And the word creator means so many different things too. It can encompass podcasters to vloggers to just bloggers or Twitch streamers, you name it. Like, so the vast scope of it is just exploded. And so it's hard to have structured kind of data points and understandings that are broadly applicable across all of the industry. So that's what I love seeing our studies put out. A lot of it is based on individual like areas of the creator economy space, but diving into the numbers behind things of what are the usual prices getting paid or ad rev payouts at different platforms. And a lot of that can help inform a creator's business strategy, because a lot of it is a business for them, understanding where they can go to chase ad dollars, or maybe there's not an ad dollar fund, maybe there's not ad dollars here on this platform, but they have a creator fund. So what do those payouts look like? And having access to that kind of data is super important. And a lot of times creators come together and publish it. There are a lot of nonprofit organizations out there that compile it and put it out there. So there's some type of understanding, but that's kind of the fun part of it. And then in my day job, the legal industry is getting flipped upside down almost because of data and because of contracts, because of generative AI coming in and being able to generate contract clauses. Legal research is a little bit more nuanced, and data definitely impacts that. There's actually an ongoing case right now that goes to jury trial this summer regarding the ability to copyright aspects of legal holdings and extracts that are made from that. So it actually put a company out of business. Ross Intelligence was the company that started up and was doing Gen AI work and AI work, not Gen AI at that point, but AI work in the early days, machine learning work around contracts and around court decisions and having equitable access to legal decisions and everything that empowers how we move forward as a society when someone sues another company, or just understanding general laws as well.
Wow. One, and I keep saying one real quick. But I did a talk earlier today, and it was with CIOs, and one of the questions was, what jobs are going to be eliminated? Which we get that all the time. Are you seeing a job reduction or a task reduction? So is there going to, and when there's a task reduction, that means there's same job but less people in it versus that job being completely eliminated? What are you going to see in the law world?
So I think I look at it two different angles. First is access to justice issues. So in the legal field, in the legal world, having access to legal resources to defend yourself or to go to court and have an understanding of what your rights are, what previous precedents are for particular outcomes. A lot of that is locked behind paid legal research tools or just a lack of understanding and ability to access the right databases.
You mean like LexisNexis and Westlaw and stuff?
Right. Yeah. Not to name specifics, not throw people under the bus, but yeah, that's essentially it. Yeah. Some of those. And if you're thinking about like indigent clients or clients that can't afford an attorney or have to represent themselves, we're even seeing cases now come up, or like news headlines come up now, where they're using ChatGPT to help draft something, and it's just making up cases. So having access to a database that can help ground the outputs and actually tie it down to cases, stuff like that, that's where data becomes hugely important from an access to justice standpoint. But of course, you have to think about it in defense of Lexis and Thomson Reuters. You look at it from their standpoint of they're investing massive amounts of money to go and encode these things, to build the databases, to maintain them, make them accessible for fees. So there's that element to it where you have to balance the business need and the cost that it would be if the government decided to do something or local governments tried to do something like that. And then even extends into PACER, which is a online federal filing database to access court filings from not just decisions, ultimate decisions that are reached, but how complaints are filed and all the different filings that go along from the moment you file a lawsuit to when it's concluded. That is also, you have to pay per page. And per page, I literally mean per page. Like it actually counts, but not on like how many documents are loaded, but how many pages are in the document and all of that. So there's a whole issue around access to justice and the ability to unlock access through the use of, more specifically, generative AI tools, but doing it in a responsible way that it's tied and grounded properly. And then on the other side, I look at it from my perspective of, I view it in my day-to-day life as a corporate attorney is it's going to unlock my ability to perform, I think, more efficiently.
Yeah.
I don't think it's going to, I'm not scared of it completely doing away with my job. Yes, there's an element where people can look up something themselves, try to find an answer, but they can do that already with Google. Like a lot of people come to me already with solutions, and I appreciate that. Or they come with their own expertise of, let's say they work in marketing. They already understand advertising laws. They already understand canned spam and all this kind of stuff. And so I'm there to help facilitate and guide the discussion towards a more finite conclusion or work through solutions to get to a better outcome for the company in that way. So that's the way that I see my job as more of a legal advocate and business partner, as opposed to just somebody that can draft a contract or read a law and try to interpret it.
Yeah, you're hitting on lots of things that we've discussed before as far as like how AI works in the workforce. It's not just going to come in and take your job, but you as a lawyer can be empowered by it. And then other folks who are not lawyers can also be empowered by it. Having said that, though, they still need you to review the end product or give them, like you said, direction on where to go from here, because there's always going to be a need to review the work. And if you're not a lawyer, you're not going to catch those things. And I was having this same conversation with a developer earlier. It's like, yes, you can use GPT to build code and to develop all you want to. Having said that, though, you're not a good reviewer if you don't know the vocabulary. If you don't know the process of development, you're not going to be able to review the end product for for QC purposes and whatnot. And so you still need the expertise. It's just like now you, the lawyer, are going to be able to do so much more than you were before.
And we're arguably, as an attorney, we being in the legal community, a legal profession, we're a little bit insulated to a degree because we do have these laws in most states where it's unauthorized practice of law if you're not an attorney licensed in that state to provide legal services. It gets a little iffy defining how do you define legal services, how do you define provide, all that kind of stuff, and can you do it for yourself versus doing it for your company or a company you work for. So I think it's worth noting, at least in the legal field, there is this benefit, if you want to call it that, of self-preservation almost, of you still have to be a lawyer, you still have to be licensed to give legal advice and provide legal advice. And I say that with the full understanding, like, lawyers get it wrong all the time. There's even that, like last year, there was that case, Avianca Airlines, where the attorneys, I think it was outside counsel that they had hired, but they were preparing a court filing, and they used ChatGPT. The attorney didn't even know that it was making stuff up, and it's like, that's not good.
Yeah, that particular case was, it was a milestone because it's the first lawyer got lazy, and got caught. But that's the perfect example because that's what's going to always happen if you don't review it.
Yeah, where it's still the same mentality of there's phases of the data discovery or the data problem-solving process. There's the front end, I always call the dilemma. There's the data and the insights in the middle, and then an action at the end. The dilemma and the action, still even for lawyers then, need to be done by humans. You have to prompt it correctly. You have to ask the right questions to get to the real problem that you're trying to solve. It's okay if AI or filtering, through searching, gets you the data and insights in the middle. But then what do you do? How do you, what's that next step? Knowing that that's a truck driver that can't take off of work, if that was one of those kind of cases, if it's a corporation, all the different aspects, or just the nuances within healthcare that are, case by case basis. So there's a lot to that. All right, enough about lawyers. Ugh. I'm kidding, of course.
Get them out of here.
Yeah. So we brought you on here for this idea. We pitched it to you, and you've been gracious enough to play along about responsible data. So we're going to let you define that for us, and then we're going to fire at you and tell you why you're wrong.
I love it.
Go ahead. So if we say responsible data, what does that mean to you?
You're asking an attorney to come up with a definition, and that's like
I
what we
love
love
it.
to do. We love to define parameters. No, but for real. So I think when we were talking, like you said, it's this concept of responsible data stems from this concept of responsible AI, which is a growing, rapidly growing industry or topic of the industry, tech industry, is this concept of what does it mean to be, if you're on the model development side, what does it mean to be a responsible model developer? What does it mean even before that? What does it mean to be a responsible gatherer of data and collector of data or generator of data? So you have those two buckets. And then if you get to the point of providing the model as a service or integrating it into your service or allowing others to access it as a service that they can integrate into their services, it begs this question, okay, then what does it mean to be responsible in that context? And then you have the output too, the end user, the output, the actions that are being taken, all of that. You have to look at it from that parameter too, of what is responsibility in that column of in that bucket of concentration. So responsible AI across the board means a lot of different things, and we don't have time to go into responsible AI.
Oh yeah, we do.
as
We
a
can go as
whole.
long as we want.
I know, right? But I don't. Yeah, I think your listeners would probably get glazed over at some point. So I think it's best just to point them. Like if you do a Google search, you can find Microsoft, Google, Salesforce, pretty much every major company has published their commitments. So at least on the tech side, at least on the platform, like the cloud provider side and some of the major platforms as well, even OpenAI and some of the other ones, Llama and Meta, have these guardrails that they've self-imposed and put out there to identify ways in which they are protecting themselves, protecting the data that's going in, protecting people that are implementing those model or AI solutions and tools. And then on the tail end, how is it ultimately protecting users? And so we're seeing some of that play out now with in the current state, depending on how people are listening right now, we're dealing with a lot about deepfakes. And that's a huge concern. So that specifically is a great example of, that's one area to focus on with responsible AI. If you're making a model available, if you're making a tool available, or a service available, or if you're the end user of it, what kind of restrictions do you have around that?
Real quick, what is a deep fake? Just so everybody's on the same page.
Yeah, so deepfake would be using let's just take an image as the most popular one right now, using a tool like Midjourney or Microsoft, I think is one of the more recent ones that has allegedly used some of their tools to create the Taylor Swift explicit images that were going around. A deepfake is using a tool. The term basically means taking a tool and creating a fake image that puts someone, it's normally in a negative context, in a derogatory context, or in a sexually explicit context, taking an image and generating an image of a known individual, or even in some cases unknown individuals, or lesser known individuals, and creating a fake image that would never existed before that. So that's why it's a deep fake. That's what that terminology means. And even down, like, the reason why some of the laws we're seeing proposed now are looking at it not just from the perspective of protecting celebrities, because previously, with name, image, likeness rights and kind of privacy rights around that front, a lot of the federal level stuff and a lot of the state level stuff was really focused on protecting celebrities because they wanted to protect their interest in being able to commercialize their name, their image, and their likeness. But now we're in a stage where that right needs to be protected for individuals, even those of us sitting here, people listening. We all are at risk of having someone, and even if you have children, kids these days are even using them to do revenge porn or to make fun of people, bullying, cyber harassment. It's a way in which it's no longer just hi, I'm a celebrity. I don't want my image to be used without permission or my voice to be used in a way that alludes to me sponsoring this product. Now deepfakes and revenge porn and all of that have become such a huge topic because of the capabilities that GenAI unlocks to just give anyone the ability to type something in, generate an image. So that's why you're seeing a lot of content filters as well on all of the
Yeah.
platforms.
There's definitely there's been a lot of news recently over like the deepfake porn stuff because like there was a popular Twitch like streamer or whatever you want to call it. There's a popular Twitch streamer or that was a part of a group, and then it turns out other members of the group were actively looking at her stuff like on stream, but they had it behind a different tab and they accidentally showed it. And then, you know, it's like if you want to see people that you know in explicit contexts, you can do that now. And to your point, it's not just the Taylor Swifts of the world. It's like, do I have a photo of you? That's all I need.
Even us on this podcast, somebody could take our voice. This is producing plenty of sample content for them to take, load into a system, and call one of our significant others or call someone important to call our business.
I told my mom that. Yeah, I was like, hey, if you ever hear me and I'm being really nice to you, you know, or I'm offering up some help, no. Let me, with the word responsible, whether it's data or AI, some different words I think about will be ethics, bias, privacy. Any other ones you think kind of fall into the responsible bucket?
Yeah, I actually like the HHS here in the U.S. has their Trustworthy AI playbook.
Okay.
And it dives in
we'll
and
have
has
to
a
get
nice
that.
little flywheel. I think a lot of it could be credited to Deloitte as well. So it's the Trustworthy AI playbook, and it's a great example. So back under the Trump administration, actually, a lot of the federal agencies were tasked with coming up and exploring this concept of how AI is going to impact their industry, or not the industry, impact their agency and how they operate and how they perform. So this was a lot of the work that we're seeing. There are a lot of government agencies that have been working at this for years before the Gen AI boom per se, and taking a look at this and kind of understanding what does it mean. And so to your point, yes, it's everything from privacy to trustworthiness, and trustworthiness can mean a lot of different things, just like responsibility can mean a lot of different things. And you notice I dodged your question of actually describing and defining what does responsible AI mean or what does responsible data mean.
Typical lawyer.
I know, right? It depends, but no, it really does. It kind of depends. Like kind of like when you mentioned earlier on, the use case matters for AI and for ML technologies, and it really does. The use case is going to have a huge impact on a whole framework of how you analyze the situation of using AI or ML technology.
Wow. Any of those that you want to tackle first, like the privacy component to it? So, because I know one of the things that you said to me when we went and spoke at the Capitol a few months ago was there's already laws that cover data, and we're talking about AI, and so that's a new tool. Does that mean that those laws don't apply to it? And so I'm thinking about like data privacy laws, things like that. Is there any? I'll just ask it as plainly as this: is there anything where you see current laws already cover some of the stuff in AI, or do we need brand new stuff out there to make sure that people are responsible?
That is the question of the day,
All right,
month, week,
I asked the question of the
year.
day.
Yes. No, so it is a great question. And I think I look at it from the framework of we are encountering something similar to when the internet came about.
I agree.
And I think sometimes people even go back to say, oh, this is like the invention of the wheel or electricity and all that. Whatever your take on that is, however you view generative AI in this space, for the purposes of this, I think I look back at it from internet law because that's more recently attributable. It's technology in that sense of more recent technology. I look at it as back in the 80s and 90s and even into the early 2000s, we had this concept of internet exceptionalism. So internet exceptionalism is kind of this concept of, do you need to treat the internet differently because it is something new, because it is different than all of the previous application that we've had of existing laws? And the answer, of course, is depends. It depends on whether it is so novel or nuanced that you do need something. So I think deepfakes is a great example of that. Right now we recognize we do have current privacy laws that protect a person's name, image, likeness, even their sound, their voice, depending on how the state has drafted the statute.
And that's everybody, not just celebrities, you're saying.
So mostly that's targeting celebrities.
Okay.
And even more so recently in the last 5 years or so, the NCAA's efforts to push into collegiate name, image, likeness rights has really spun and spurred a lot of development over the last couple of years from the state level to protect that and offer that as a protectable right and an actual right.
Yeah.
That's the important thing. Is it a right that someone has? And so that's why we look at it. Yeah, go ahead.
Well, no, that is the question, because why do any of this if it's not a right that we have a sovereign, name, likeness, and image?
Yeah. And that's why the right, if you think about, well, what right are you talking about? Well, ultimately, all these fall under a bucket of privacy rights because it is your person, your interests that you're protecting as an individual. A lot of times, like I said earlier, it is oftentimes tied to commercialization of it. Except if you look at it there's a lot of Supreme Court cases, there's a lot of law built up over the years about right to privacy in your home, how that's expanded to even be outside your home, and that gets into a lot of even down to like reproductive rights and things like that. So the right privacy is such a broad sweeping category, especially in the digital space. That's where you're seeing now a lot of them are targeting the ability to recognize this newer concept and making sure that, okay, we recognize from in what I call AI exceptionalism, we have to re-examine what we have and where are the gaps. And if we have gaps, maybe we can close those gaps like we were just talking about and provide this right as an actionable protective right for individuals that aren't maybe well known or that aren't trying to commercialize something.
But with that one specifically, the strategy is just to copy and paste stuff that's already afforded to some to all. Whereas like is it not?
It's not necessarily. So copy and paste. So I don't want to get too much into like playing one side or the other, but there are people that argue it's poorly drafted. The way that they're trying to go about it now is poorly drafted because it's lawmakers trying to just push something out ahead of elections. They didn't take the time to truly understand the technology and how to properly, again, getting back to definitions, what are the defined terms they're using to identify this? And the other question there too, a lot of what we're seeing in some of the newer bills is platform liability. So service provider liability, the liability of, like I said, this gets to that.
That's a whole separate conversation that I do want to come back to in a little bit, but keep on going. I don't want to go deep in it just yet.
Yeah, no, that I just want to highlight that's where some of the critiques are coming about from this perspective of these laws. What is the aim here? Is the aim to give individuals a private right of action to take and to pursue, or is it to hold someone accountable? Are you holding the actor, the bad actor accountable, allegedly bad actor accountable? Or are you holding the platform, the tool provider, and even going like a broader in scope over to the EU? The EU AI Act accounts for this and distinguishes between model developers and distributors and platforms and users and all of that. So it just depends. Like I think it looking at what law, what area you're trying to cover and provide a framework and try to analyze around, like, is this sufficient in the AI age? Kind of like back in the day, we were saying, is this sufficient in the internet age? Yeah. And a lot of times we were determining like, okay, we don't have adequate means of stopping mass copyright infringement that's destroying the music industry, or we don't have a means of platforms being able to operate without being held liable for anything their users post. So we have Section 230, and the DMCA has solved a lot for mass copyright infringement in the music industry and film and all that. So it's kind of cycling back. History repeats itself, and I think we're seeing that now. We're at the stage where it's trying to, even now, copyright still comes up in this space of understanding how do existing laws, how do they apply under an AI ecosystem and framework, and do they or do they not hold up? And if they don't, then maybe we can talk about where the gaps are.
Gotcha. What do you think leads to it not? Like, is it the fact that AI can now make decisions instead of just, give you insights? And that really goes back to the liability question, right? Charlie, and the idea of who is responsible. Is it the data? Is it the ones that build the models, or is it the ones that use those models? And so there's some aspects there. Charlie, what do you think about that? I want your opinion before we go to Franklin on that.
On the distribution of responsibility?
Yeah, I'll give an example. Let's say I'm a data aggregator for real estate data, and I am using somebody else's model to build a model, but it's their model. Yep. And then I am then leasing that to real estate companies, right? So now you have real estate companies that are using a model built by somebody else, or at least the way it's built, but it's my data. And let's say there's something that was falsified, in that data or that was on the at the end point was wrong, which of those three should be reliable? All three, or two of the three, or none of them?
I feel it's like it's definitely a shared burden, but I'm going to take your analogy you just gave me and I'm going
Okay.
to throw it in the garbage.
Yeah.
And I'm going to use a weapon analogy instead because that's how I was wrapping my head around it. And so if you're a weapon manufacturer, do you get to just do whatever you want?
Absolutely, they do it now, right? Isn't that what Halliburton? I have no idea. Of course not.
They have rules
Of
and
course not.
regulations,
Of course
obviously, around manufacturing a weapon, and the reason is because it can be harmful.
Mm-hmm.
And so if you're a media platform, you can unintentionally host harmful things, and so those things can in fact do damage. And so you as a we'll call them tech company or host are liable to some degree or another. I think the bad actor is ultimately like the primary, the alleged bad actor, if you will. And so they should always be the one treated as the one who pulled the trigger. But you as the manufacturer, or you as the host, have a responsibility to maintain at least a level of responsibility when it comes to what is on your platform. And I'm not saying that everything comes with a huge penalty or anything like that, but you've got to moderate. The problem is that right now, a lot of these platforms, they weren't built with moderation in their financial plan. And then in some cases, recently, moderation was taken away from the financial plans. And so that in and of itself is irresponsible, I think. Mm-hmm. And it's irresponsible that it's not considered in the way that it should be. But then you've got the YouTubes and stuff like that where they're adding, like a lot of platforms are responsibly adding on to what their moderation is and looks like. And that's great and everything. But then we're in an infinite growth economy. So at some point, somebody's going to start cutting something and it's probably going to be in moderation. And we've seen that. So
Yeah.
with the takeover of Twitter, like one of the first groups to go was the support team. And because they're like, we'll AI this up and we'll get it going, and Gronk is gonna take care of everything.
Rob Gronkowski or Grok? It's Grok without the N, isn't it? Yeah, I think so.
I say it wrong on purpose. Like I have a disdain for Twitter as a company right now.
You have a disdain for Rob Gronkowski?
No.
I think you mean X.
I don't actually. Now that you mention
You're
it,
intentionally not saying.
Oh,
yeah, I still call it retweets and everything. But the
Well, what else would you call it?
yeah, re-X's.
they call them
yeah.
reposts.
Oh, do they?
Yeah, they do.
Yeah, I like re-Xing better. No.
Anyways, I feel like it's a distributed model for responsibility, but the ultimate like whoever pulled the trigger, unless it's willful ignorance or maliciousness on the host's side, that it's mostly on them. It's mostly on the bad actor.
Okay, so in your case, the weapon manufacturer, is that the data or the processor, or that's both there?
That's the host, and so it's like where the data comes from. So if the data, if like I'm thinking about it from like if I put something on YouTube that shouldn't be there and it stays up for way too long, then it's the platform's responsibility. But if I put something up on YouTube and it gets caught immediately, those 3 seconds it's on there, like I can't do better than that right now. And so that's the holder of the information, and then the manipulator of the information is who I'm talking about being the bad actor.
Gotcha. Franklin, tell him why he's wrong. I'm kidding. Actually, I think that was well said. What can you add there?
Yeah, a couple nuances, I guess. So, like, thinking again, applying existing laws and regulations across industries, products liability immediately comes to mind. That would be something that the gun manufacturer would potentially be liable for if they do not adequately manufacture and produce and sell and distribute. If they're the distributor of their products, then products liability could be traced back to them, and that's under law. Same thing, like in the internet age, we had this concept of service provider liability, and that developed over time. And Twitter is currently facing that. And so because they've removed their content teams and because they've removed teams that their safety teams, they've removed these people that even respond to like DMCA takedowns. And there's actually, it's kind of interesting, they're being sued because of failure to respond to their takedown request. So they're being sued under the DMCA for violating that. Because as a service provider, And some of that did stem technically prior to the acquisition, but a lot of it still continued post-acquisition under that law, the time frame of that lawsuit. But
DMCA, go ahead.
I'm sorry, yeah, the Digital Millennium Copyright Act. It's a section of the Copyright Act that focuses specifically on digital copyright.
If you
issues.
listen to any YouTuber talk, they talk about getting DMCA.
Yes. Yeah, it's where you see like it's basically it is one of the reasons why YouTube ended up developing their Content ID system. That plus the slew of lawsuits that YouTube and Google faced early on in the earliest days of YouTube, surrounding like hosting content that's copyrightable and not taking it down, all that kind of stuff. So it was this framework that was developed around what, like to your point, what is the responsible time frame in which someone should respond. So content moderation is a little bit different. Like it's arguably under the umbrella of content moderation, managing copyright claims and trademark claims that are received on a platform. But from a content standpoint, I would argue a little bit with your distinction of just because content is hosted for a while and it ends up being harmful, doesn't necessarily mean that the platform should be liable. It's just, I would argue that under the statutes, as long as they have a robust and a reasonable content moderation system in place for their platform, and they're catching the vast majority of it, then they're probably in the clear. But I think we are seeing social pressure, government pressure, just like even last week when all the executives from all the major tech platforms were called, or maybe that was this week. No, it was last week.
It was
last week. All the major tech platforms were called in. Not all the majors, but everyone from Snap to, of course, TikTok CEO was there again to grill China, even though he's not Chinese. And then the other aspects of that, like Linda from X was there. And they were all grilled because all of that is stemming from pressure, societal pressure, as well as congressional pressure about the alleged lack of protecting children online on their platforms. So that's where you're also seeing that, well, maybe that's a gap that people are identifying. So maybe that's going to be a way in which new laws are drafted and regulations are drafted. Maybe it's an exception to Section 230 of the DMCA, which doesn't allow a service provider to be held liable for hosting content at the direction of a user. That's one of the distinctions of what Section 230 does. But they have to have reasonable content moderation policies and practices in place. So
to step back from that, so they can be okay in this situation so long as they're following the rules of or the rest of the rules on moderating.
Put very simplistically, yes. Yeah. That would be the argument.
I'm thinking about the folks out there in listener land.
Yes. Yeah. Thanks for clarifying that. Yeah. I think that's a great way to put it. But yeah, I think even taking this back to this topic of data though. So like rewinding a little bit now, like we talked about service providers, we talked about platforms. Where does this leave us from a data perspective? We're seeing that with publicly accessible data sets. And the concept of even like data cards. And that gets into the concept of data provenance and this concept of what data set are you working with? Do you know where it's coming from? Who compiled it? The origins of the data that's a part of it. And that's where the Google and Microsoft both have two good examples of templates for model cards that can be used. And the way you can think about model cards is it's kind of like if you go on GitHub right now and you look at like a repo for some type of project that's there, you have like your about like the README file. And it breaks down kind of about the project, what it's all about, if it's a well-done project, and it has that all filled out, of course. And you'll see all of that. And it might even include like limitations, or you can go into the contributions or the open issues and kind of understand what the limitations are. It's the same kind of concept in the data space. So if you have a data set, it will identify what are the biases. Are there any gaps in the data collected? Are there any risks associated with the data? Because it might be PHI. Hopefully it's not out there publicly accessible as PHI. But things like that, you can kind of identify in a model card around the actual data set or the actual model. It's meant to accompany a model that's developed and identifying attributes, almost like metadata, of the model itself and the underlying data that was built or that was used to build the model.
All right, so pause. Let's take like 2 steps back. You said data provenance, and then you started saying a whole lot of stuff right after that.
Provenance. So
yeah,
we'll have to make sure that's in there. But yeah, it's Provenance, and I'm reading it directly from our notes that Franklin gave us. So that's new for me as well.
Okay, and I caught the part where it's like, is it a dubious authority? Like, do we know and trust the data? And with the world we're going to, if you wanted to be a little sneaky, you could probably make up your own data or manipulate some data. I'm actually dealing with this professionally in a way too, so it's exciting in that like folks, they're used to getting away with some of this stuff, but with the data they can't really anymore. But I digress. So you've got a set of data and you don't know if it's good or not. So qualifying it as data that's usable, that's the provenance? Or
I wouldn't say that's the goal of data provenance, because I think that question can only be answered by the end user of the data set.
Okay.
And so I think if I'm out there on Hugging Face looking for a data set, I, as the all-knower of the project I'm working on, can understand whether or not this data set is going to have limitations that simply will not work for the type of model we're trying to build, or the type of model we're trying to fine tune, or the type of work we're trying to do in this sector, or for this project. So is that helpful? That's kind of how I view it.
So it's almost, to me, I'm hearing it as it's an origin story. It's giving you some specs on where it's from, giving you the idea of it's from this neighborhood versus that neighborhood kind of thing. But it's data.
So it's essentially like a less formalized blockchain type idea.
That could, and arguably you could use blockchain technology to further authenticate the data sources.
They're not mutually exclusive,
right?
But you don't have to have blockchain to approach it in the same kind of way.
Another way to think about it, and this is also a great way to segue back into the privacy discussion you're asking about, is when it comes to, I think Apple did a great job of bringing to the forefront a digestible, and that's a pun. I'm about to get to why that's a pun. A digestible way to understand your privacy rights. And they developed what are called they call their data nutritional labels. So if you're a mobile app developer and you're releasing an app on the iOS App Store, or whatever other ones they have so many now. If this new requirement that you have all these, what are essentially metadata data points filled out about what data your app is collecting, how it's accessing it, how it's going to use it, will it be commercialized, this whole slew. And it basically is presented to the end user in a digestible way, in the way that when you look at a nutritional label, we're all so used to looking at nutritional labels on food to understand, okay, what's the serving size, what's in this, all of that. It's the same concept that Apple's done with our privacy within their ecosystem. It's the same thing that is also being done. That's how I would view a model card.
Okay.
I love that.
That actually makes that puts it into perspective in a way that it wasn't clicking before.
Which is Apple. Apple's good at that.
So. We love. Oh, you're an Apple guy now, don't you?
I'm not. I only participate in the ecosystem because I have to. My friends will literally
he likes
not
to.
Well, under EU law, you don't have to. Move to the EU.
My friends will literally not include me in group messages.
Yes,
Are you a green?
No.
Oh, okay.
Okay,
you were. Okay.
I had to see. Okay, see here.
You solved your problem.
This is.
Yeah, you were ruining our text chains in the beginning. Yeah,
I digress.
Yeah. Can I ask a question? You mentioned it. I say it all the time, and I might be wrong when I say it. Publicly available data. And people will say, "Well, what is that?" And I'll be like, "It's the internet." But what is if people say publicly available data, like everything that's been part of the OpenAI model, right? Oh, publicly available data. What does that mean?
Ooh, let's go there.
All right.
Let's unpack this one.
I love this topic.
Yes, this is a heavy one. Yes, it is important. So the best way that I've found to communicate this and to developers that I work with is to think about it as if you're looking at open source code, an open source project that you're wanting to use. Mm-hmm. In the open source community, there are dozens of standardized open source licenses that can be applied to your project. GitHub makes it super easy to choose from a list or whatever, or automatically apply your organization-wide. You're going to apply MIT or whatever, your own custom copyright notice. So in the open source realm, you're talking about copyright ownership over the code. And some of it does, some of them also get into whether or not you can use the trademark of the organization that might have been sponsoring the open source project, or it might even touch on patent rights. If you're waiving patent rights, or if there is a patentable process or some aspect of the code that would be subject to patent protection. So that's the purpose and intent behind open source licensing.
Okay.
And the whole intent behind it was to have a standardized way of quickly moving and having contributors and open sourcing a project so that others could come and contribute to it. And you can understand, okay, am I contributing to something that is truly open sourced in the sense of what that means to me, or is that open source that's too closed? Like I don't really want this too copy left or too copyright. It kind of helps people understand what the project does, or helps corporation maintain ownership over it. So that's what I use. And most developers, I think it's fair to say, anyone that's has been working in code understands the importance of understanding what open source license applies to code that you're going to pull into your larger project, or that you're just going to take off the shelf and run as part of your solution that you're developing internally. So it's similar to that in the sense of that same concept should be applied when you're thinking about data sets. Just because something is publicly accessible on the internet doesn't always mean that it's just fair game.
Oh, okay.
And the reason why, you might be asking, is
Well, that was what I was about to ask.
I see. This is why I'm good at my job. I
you go.
anticipate the next question.
That's it.
But so that's the question, though, is if you look at a lot of the content that's available online, and this circles back to what we were talking about with platform liability. They're not liable if a user posts a copyrighted image or copyrighted, like if I really love this Taylor Swift song and I'm going to post it on my X account and just share parts of it. I arguably am not going to get a takedown from Taylor Swift because I'm just sharing because I'm a fan, all that.
Gotcha.
But the reality is the platform really should not be using that content, and others should not come along and scrape that content because it's subject to other rights that I, as the individual user, did not have to post. I'm using it in a different context. So if you're scraping, and that's kind of the heart of the New York Times case, and one of the issues.
Gotcha. Go ahead. Explain that case, because I vaguely understand it, and I know you're going to make it sound crystal clear.
Oh my goodness, I will try. So OpenAI and Microsoft are getting sued by the New York Times because they have allegedly done scraping and have used the content that New York Times has published online to train their GPTs.
Now, was that so? My understanding is it's not like they put an entire article out for the public, but they may have put a snippet, and then some other people are quoting it, and so all of a sudden it can be recreated, even though it's behind a paywall. Is that part of that as well?
And that's part of what the arguments are. Is did OpenAI, because OpenAI is the developer of the models, did they actually go to the New York Times site and actually scrape full articles? Could they? Or was it behind a paywall? And so I'll stop right there and just pause for there, because I'm actually teaching a cyber law course for a law school right now. And just last week I was discussing trespass to chattels, which might not sound like anything to you all, but it's essentially this concept of, if I'm browsing an internet website, what are the rights that owner of that internet website has to prevent me from taking content, scraping it? And so it kind of gets into the heart of, go ahead.
What'd you call that?
Trespass to chattels. It's like a...
Trespass to chattels.
Yes.
Okay.
Yeah. So it's essentially this concept of, if you think of property, it's a area of property law, and torts are harms that you suffer, and trespass is one of those. And so if someone is coming onto your site, which is your property, and taking content from that, is that illegal? And right now we don't have a lot to go off of, because that's not the only question that has to be asked. If something's publicly accessible on the internet, the Supreme Court, in a case called Van Buren, said that you should have this concept of gates up, gates down, which if you have your website gates are down, anything can be accessed, then arguably it's fair. It's fair for someone to come and scrape that content and use it because it's publicly accessible. Okay. However, if you have it behind a paywall, like the New York Times, that is a protective measure that they're taking. And there are a lot of questions left unanswered by that case, such as, like, if your terms of use for the website say you can't scrape, is that sufficient? So it kind of, it's a lot to unpack in that sense, but that's there's a lot of previous internet law history that comes into play in this new realm that we're in, of the importance of either being able to legally or illegally, whether it's legal or illegal, to scrape content from the public internet, because one thing in particular is whether it's considered a harm to the host of that content.
Yeah.
Well, you could sit in the case of the New York Times, if you scraped, like if they paid a subscription and then went and scraped everything behind the subscription, you definitely harming them.
So this is where it gets, I love talking about this case, because it's so, the irony is just lovely. So Microsoft owns LinkedIn.
Yeah.
LinkedIn, you have to have a user account to be able to see the data.
Yeah.
They actually sued a company called HiQ. They sued them because HiQ was scraping public profiles, and maybe there was a case where they did actually create accounts to go and scrape profiles from LinkedIn to build a database. And you can imagine the benefit of that to businesses to have a database of people's current jobs. It's like voluntarily you put that out there.
Yeah. And you don't have to show them that you were looking at their profiles. And
Right.
all
And
that.
so I love the irony of it, because LinkedIn was involved, which Microsoft owns, was involved in suing them out of business basically for scraping. And it's a great case to look into, because it dove into those nuances of what Van Buren started and kind of the nuances of what does it mean to have a gates up, gates down, where terms of service come in. And in that one too, it's also important to think about like the data is not really copyrightable data, because it's personal information. You can't copyright personal information. It's hard to claim ownership over that.
But you're definitely hurting the LinkedIn business model and the people and the investors in that company.
Or the expectation of users, because I guess LinkedIn could argue, like, if I'm a user of LinkedIn and LinkedIn has done nothing to stop this, I don't want to be on LinkedIn anymore.
But to your point, LinkedIn is a definite gated community.
At this point, yes.
Yeah. So how do you think that from this perspective, or from this point in time, like, how do you think the New York Times thing is going to play out?
Oh, that's a good
I'll
one.
be a judge.
So there's also another case that is Authors Guild related, where authors are suing because their content's been scraped in. It's interesting when you think about it from the perspective of studies that are coming out now. And I try my best to read and get a holistic view, but it's impossible to keep up with everything every day. But I've looked at a lot of studies, and it's this concept of, and I beg the question myself, when you're training a model on I call it pre-existing materials, because I think it's. Side note, if you're working with model cards or data provenance, I prefer to use the term materials, because I want to understand it's not just data. It's also, it might be PHI. I think it's important to name what you're working with.
Personal health information.
It might be personal health information. It might be personally identifiable information, PII. It might be copyrighted information or information that is protected by copyright laws. It might be public domain information. It might be subject to Creative Commons licenses, all of that kind of stuff. It might be subject to open source licenses, which is what GitHub is dealing with right now in one of their cases.
Like, it could be sensitive in some way, shape, or form.
Right. Sensitive or protective or proprietary. And so that's why I think, as someone who's advising teams on use of data sets and use of models, to me, it's important from a risk liability perspective to understand, okay, what is the liability of engaging with this data set and reproducing it? Because that's what some of the lawsuits, like on the image generation side for Midjourney and Stability AI, a lot of them are involved in cases. There's over a dozen now copyright cases surrounding this. So we can go on and on. But those in particular are looking at the Lion data set out of Germany, which is a data set which is just links to images online. And it has the associated description and kind of stuff like that. But in order to use that data set and have it to build a model that can become like a Midjourney type model where you can do the fun text image generation, you have to copy the data. You have to copy the images from those links onto your own server in the cloud, arguably, and then use that to train and build your model. And so that's the act of infringement in a lot of these cases that we're seeing, is they're claiming that act of copying is unauthorized. You're making a copy of those images from the internet without the permission of the owner of those images, and you're using them. And so that's when also we're going to see this argument play out of whether that's a fair use defense or not. And then it's this other question of, when the New York Times specifically, just because something is publicly available online, is that going to mean it's fair game to be scraped and to be used, or is it going to be limited to what's just behind a paywall where you have to license it and it's proprietary at that point?
So you didn't answer the question, though.
I know. I try not to share my own viewpoints on this.
Okay.
But no, I don't mind doing it. But I think,
will, though.
I will say I'm torn. I recognize the immense value. So kind of where I fall is, I'm as of right now, my views are subject to change.
Sure.
I view it as impactful on creative industries and creators to be able to have someone that can scrape something that they've put out on the internet.
Yeah.
Because that's the nature of the internet. You put it out there for public consumption. if that means that can just be scraped and used up by somebody that's going to then create a product, an AI model or a service that allows others to basically not come to me for that same image or come to me for a similar need, what does that mean in the future of creativity, in the future of the world? Because to me, that kind of is a harm in that sense.
Yeah.
But outside of that, what if you're building a security system to recognize images and objects, and that is, do you still need to license all of that, or because it was publicly accessible, there's not really a licensing model for that anyways? Is that fair game because it's a completely different industry? It's not impacting the underlying rights and market for that original content. There are a lot of holes you can poke in either direction, but yeah.
Wow. Well, I love the lawyer speak stuff.
Well, what do you think about that same question then? Because I don't want to change subjects yet.
I do. I'm ready. I'm ready to. I want to get to know Franklin as a person. When it comes to this, I feel like I'm on both sides too. I want to see how it plays out because I notice that I am taking one side versus another. Sometimes mainly for discussion. Like I feel there's this. There's almost an unfair opinion toward machines compared to us. So it's okay for me to be influenced by the Beatles, but it's not okay for an AI model to be influenced by the Beatles. If that
Without
makes
permission.
sense. I don't have permission.
I mean, theoretically without permission.
Yeah, and I think I do technically have permission. I think the Beatles would say, I'm pleased.
I'm talking about the machine.
That's right, but I also don't as well. Like so, if I'm writing, I am writing based on books I have read, right? If OpenAI's models are writing, it's basing it on the books that's in there, and we're mad at the models for that, but we're not mad at people. So this is
We are if they get plagiaristic though.
but they're not. They're influenced, and GenAI is not plagiarism. It's influenced by. It's a probability.
Statistics, probability.
Yeah,
It's
a probability
computational
of
analysis.
the next word being generated based on previous works, and that's where I don't know what I just said I believe yet.
Yeah.
But I keep trying to think both sides, and I think I'm playing the other side so much lately that I'm starting to believe it. But I do wonder. There's influence. Our brain is a GPT model, right? A lot more sophisticated, a lot more connections, parameters, all of that kind of good stuff. We've talked about that many times on here.
Yeah.
So why is it? It's generally accepted that we can copy, and imitation is flattery at this point, until it's plagiarism, right? Or flat out stealing, where any influence within a model seems to be taken negatively, and I'm not sure if that's right or wrong. Now, I do think, first of all, if you're flat out stealing articles from behind a paywall and you have the ability to put in a username and password while you're scraping, well, hey, that's a little bit too far, right? But are they, or are they getting the snippets that are publicly available? So I don't know, and you know, I would almost say, is it okay that publicly available, like Taylor Swift's stuff is out there, right? It's on YouTube for free. Does that make it publicly available, or like you said, accessible? And should that be used? And if we are trying to generate music, it has to be used because she is a huge influence. I mean, there's about 50 Billie Eilish sound-alikes out there right now. We're not suing them, but they only sing that way because of Billie Eilish.
And parody is allowed.
Yes. Yeah, that's true. Weird Al did have a really good career, didn't he? He probably got sued a lot, though.
He asked,
So he actually had permission.
He didn't do some. He asked permission, but just because he wanted to.
Yep.
And
He didn't have to.
He was denied in a couple of occasions and didn't do it.
And now
Just 'cause
the
he's a
two
cool
live.
And I like Weird Al even more now. See, what a great guy.
But I did want to just one rebuttal real fast, and the reason I'm doing this because the same question came from an audience member when I was speaking at GenAI Week in Atlanta last year, and it was the same question, this concept of why are we holding machines to a different standard than we hold humans to a standard? He this audience member specifically said, if I walk into a museum, and I walk around the museum and I leave that museum and I paint something, I'm inspired by that. How is that any different? And my rebuttal to that is what you're talking about on we have to get out of this concept of humanizing what machines do.
That's a great point.
And so
Great point.
it's dangerous, I think, to put them in that realm because we also don't want that to continue that I'm going to butcher the word, but
I
yeah.
say that bad. I
Yeah,
say
yeah.
that all
Anyways,
the time.
we don't want that play to continue on down when we're actually like allowing it to make decisions, or when we're allowing it to do certain things and be responsible for certain actions. So my rebuttal to that is, we as humans can walk into anywhere or consume any content in pop culture or whatever, but our brain is not making an exact copy of it. We're not retaining a copy of it. And that's exactly what is happening with the models, is their ability to ingest billions and billions, like I said, the Lion database, it's billions and billions of images. Humans will not see that many in their lifetime. And so I think that's the true distinction to be made between that type of interpretation of it, is you can't humanize something that's not human and that is doing something that is arguably and probably factually inhuman to begin with. And that's why I mentioned I love reading studies on, like, there was one recently about analyzing whether machine learning models are actually, and deep learning models are actually just data compression mechanisms, because they are able to uncompress and reproduce almost similar images, or almost exactly similar images, which is what we're seeing in like the Getty Images case that was filed, the lawsuit there. It was trained so much on the Getty Images trademark because those images are just publicly accessible and out there as thumbnails, but the licensed version's not. The model would recreate the Getty image for a lot of sports content that it was asked to produce, and that was the heart of one of the Getty Images lawsuits that was filed.
Wow.
Well, let me ask you
Did
something.
you answer that question, by the way?
I don't know.
What would you how would you decide on the New York Times?
I wanna have the ability to say this is mine, and you can't touch it. So I want to, if I build a website, I want to have something that I can click that says keep your scrapers away from this.
But if you're putting something on YouTube, I'll go ahead and take the other side of the argument too. Like, if you're putting something on a platform like YouTube that is arguably, it is taking your content, analyzing it, producing subtitles automatically, doing closed captioning, or helping you analyze your audio to improve it at a click of a button. There are elements of where, like in the creator space, platforms are taking content that users are putting through their platforms or through their systems to improve the system as a whole. And that's where you have to have this discussion of, okay, am I okay for my data being used for that purpose? And most of the time the answer is going to be yes, because it's the benefit of everyone.
Yep.
Even right now, if somebody's listening to this podcast on Apple Podcast,
Yeah.
they just released that they are going to start allowing transcripts for their podcast.
Yep.
That is machine generated.
So that's true, and that's something else that I wanted to get to. But the like, to go back to the analogy that the audience member was talking about, like, so he went to a museum and looked at a bunch of stuff.
Theoretically. I can't say if he did or not.
Yeah. That's the story that we're going with, at least right here. But the thing that he's not qualifying is that somebody had to build the access for him to be able to go in and do that, and then permit him to be able to go do that.
And curate that data set.
Yeah, and so the internet works the same way. It's like the internet. If I build a website and put something behind a paywall, that's the same thing as a museum. And so is somebody going to go into, because we can't say we're doing some of this physical and then I'm going to take it and change it mentally. It's like, since we're just physical, he's not going to walk out with those pictures to then have one right here so he can make a facsimile or something like that. He's just going to look at it and he's going to take that impression home with him, and then the impression is what stays. And
but he can take a picture. He can use his phone and take a picture.
Or maybe not.
Or maybe not. That's a rule that the museum gets to apply.
And even if he took a picture, he would probably arguably still be violating copyright law.
Ooh, good point.
It depends, yeah. Depends.
But like a YouTube, they can have similar rules. It's like, you can view this stuff, but you can't take it with you. Like, and that's completely fine. And I think that needs to be extended down to the person as well. It's like, you can look at my stuff, but it's mine. And like, there's a guy on the internet now that I love pixel art, and he's a pixel artist, and he's committed himself to one image a day, and he's 100%, and that should be his, and in no way anybody else's, unless he says otherwise.
Which is why NFTs came into play for a while.
Well, yeah,
right?
that's a whole separate conversation.
Yeah, and let's
about
not
ownership and stuff like
let's
that.
not go there. That which I'd like to know what that website is and put that in our show links.
put it in there.
I think pixel art. Anybody that had a system way back in the day when it was 8-bit, you dig that kind of stuff.
But if somebody scrapes that, I think that's stealing. And I want GenAI to move as quickly as possible, but I also want to keep people's creativity for them. I want people to be able to keep their creativity to themselves if they want to.
Yeah, it's so hard. I feel like I've always been in this dilemma of privacy versus availability. Going back to the days when I would teach security in the IT space, and I've always been conflicted. So it's always hard. I'll say something today, like honestly, Franklin, you convinced me I'm wrong, right? This idea that machines are not human, I need to think about that more when I'm thinking of some of the cases or dilemmas that I'm going through. I think that is something that is hard to not do. I mean, we want to put a face on the models, right?
Try and say the word.
What word?
Anthropomorphization.
Yeah, I don't even know how to say it, so I'll let you do it. Did you look it up?
Because that's it, but it sounded it's hard to say fluently.
Yes.
There are just some words. I had a really hard time growing up ever saying the word funeral. I could only say funeral.
Fernal.
It took me a long time, and I need to practice.
Yeah. Well, speaking of you, Franklin and Charlie, I'm going to throw this at both of you. Let's talk responsible AI, responsible data at the personal level. What are some of your do's and don'ts? You're not as a lawyer, not as a CEO of a company. You personally, what are some do's and don'ts that you feel? So I already feel I like the one about if it's my personal website, my personal domain, and I want it to not be scraped, I should have that right. So I got that from you, Charlie.
Well, it's not just anything I build, like a personal, like company wise. Like I put it, if I start a business, I can lock the front door.
Yeah. But what if you put it on somebody's platform, like a YouTube? Do you does that change?
I think it transfers liability to the platform because you're entering into an active partnership where you've signed EULAs, you've got an agreement going with them.
Yeah. Okay.
And so
it's very favorable to the platform, though.
that's
very,
true, but
very favorable.
you agreed to it.
Yes.
And yes, and they'll monetize, but they'll change that anytime they feel like it.
And they frequently do. Yeah.
Yeah. Do you feel there's any do's and don'ts when it comes to making decisions with data or not, or storing of data? Anything that you feel is good for our audience?
Yeah. So one thing I'd close the loop on with the discussion we were just having is it's easy to talk about this in the context of creative works with outputs that are synthetic media of some kind.
Yeah.
And if you look up synthetic content and the initiatives that are happening around trying to have content authenticity, Adobe is a big player there, Microsoft's a big player there, a lot of big players in that space now. I kind of take a step back because that is one aspect of the work that I do. But the other aspect is working with developers that are developing these tools. And again, the reason why, like with the model cards, I prefer calling things what's the underlying, what are the pre-existing materials, what are the training materials, it's training data, but in reality, I like to refer to it as training materials, because just as much as the outputs could be infringing if you're using an image generator, or could potentially you can prompt it in a way that you can use the name of a well-known person that has been photographed millions of times and have that drive how you control the look of a character in your comic book, which is what Chris Castanova did. They did that for their book, their graphic novel that they tried to register with the Copyright Office. Look up that, the prompts that were used there. I look at this outside of the creative space, and I also look at it in just everyday kind of products and services that are being developed. What does it mean to be collecting personal data? What does it mean to be collecting personal information, sensitive information about people? And then how you're using that. And if you're using a model that is going to be a continuously learning model, or if it's going to be a static model that won't learn, those would be some decisions to make. And maybe you're choosing to not use raw data. Instead, you're going to create a synthetic variation of that to where it's not identifiable anymore. It removes those identifiers, things like that. That's where responsible data really comes into play from my perspective at a professional level and at an advising level, is to understand that, like, even just I try not to get bogged down in the headlines because that's just going to stifle innovation and development. But like the ability that people can pull out and extract phone numbers, social security numbers, addresses, all that kind of stuff, real information about people because the model that was used, I don't want to use names because I don't want to be disparaging, but a model that was used and just trained on the vast amount of information on the internet, that's a risk. And so those are the types of things that you got to think through. And so that's one of the things that doesn't keep me up at night, but also is just one of the things I always try to drive home is understanding the training materials that you're using and how that will inform the decisions you make on the architecture side and on the development side as well. But in my personal life, I personally choose to use Apple. And I love being able to understand the lockdown nature of where my data goes. So like I use Apple Fitness Plus, I get all the prompts, and I understand that by using a workout that is doing benchmarking against other people that have done the workout before me, and my data is contributing to that, and I'm fine with that. Like to me, I think Apple has a great framework for identifying how to disclose what's being done, and no surprises, and also capturing those consents pretty much almost every time, or if you ever update your phone, stuff like that. So I'm a big fanboy in that sense, and I think Microsoft has done a great job too of doing similar initiatives of making sure that it's clear of where data is going and where it's not going, how it's being used and how it's not being used. And even more so in support of that, Microsoft a couple of years back launched their open data initiative. And I thought that was a great resource to go look at. If you look at the landing page for that, they actually have a couple of on the legal side, a couple of licensing agreements that can be used that identify, kind of like I was talking about earlier, open source licensing. There's open data licenses. And Microsoft has like 4 or 5 good examples, some for research, some not. And so it's just those are the kind of things that I like to look at and dive into and reverse engineer if I can to kind of understand and think through what's going on.
Gotcha. Charlie, anything when it comes to responsible data or AI that personally you feel is a benefit to you?
The only thing that I would encourage people to start thinking about is like, and you kind of hit on it briefly, like what if people see your stuff? Like what if your data were to be exposed? What happens then? So I personally try to live my life as if my data could be exposed at any point in time. And, it's going to be embarrassing for sure, but I'll live. I'll make it through, as it were.
Yeah.
But it makes life hard. It makes life harder for sure when, everything you do could be visible. But really, like, if you sit and daydream about, like, how likely is it that your text messages are going to be leaked to the public at some point? Or what happens to your text message threads right now in 60 years? Like, are you going to be a 75-year-old that your entire life is exposed before you die? And then what's going to happen, like, once you've died? Like, your kids are going to be around, and then you as an adult have your data exposed, and then the entire family tree's worth of drama is exposed. And so I think living like those are the inevitabilities is a good thing personally, but also I don't mean to be too doom and gloom, but just knowing that's a possibility, and then like do as good as you can, but be ready just in case. So if you've been up to shenanigans, just be prepared to explain them all.
Wow.
Yeah, I would say if nobody knows what you're talking about, there's a great book that just came out, I think last fall by she's a New York Times reporter, Kashmir Hill. She wrote "Your Face Belongs to Us," and it's a great look into how privacy has been impacted by data scraping. And that one in particular, to your point, is eye-opening if you've never heard of the company that back in the day scraped publicly accessible photographs from Facebook and anywhere online, Flickr, and has gotten to the point now where you can identify any individual. They sold it to law enforcement officials and all that. And so that is a real discussion that needs to be had around responsible data and having stuff publicly available and therefore publicly scrapable.
Yeah.
Well, it's not just when it's purposely publicly available, but like, hacks happen all the time. Like,
Sure.
There have been many notable instances of data like getting out of the walled garden and then people being exposed. literally.
Or even, like I mentioned earlier, improper development of models, where it's not privacy first or privacy preserving development, privacy preserving model,
It's by
where
any means.
where you can be linked. Yeah, and if you think about it, then what happens if a bad actor gets a hold of that model and can extract data points from it? And
They will. That's the thing. Is like inevitably, like once the data's out there, a bad actor is going to touch it.
Yep.
Yeah, and I think for me, because I do modeling, I'm probably that's where I feel like I'm most cautious. I've been trusted with data that is personal identifiable, and I have to be the one that masks it sometimes. I mean, I actually got a data set one time with tax ID numbers in it, and I'm like, "What are you doing? I did not need these." And they just hit star and sent me the file, which just means that they sent all the fields from all of the tables. And so I'm always thinking about, do I need that? Do I need this? Why? And people will say, well, that makes a better model, but does it? Why? Like, I'm not interested in the prediction. I'm interested in the factors. And so keep it to the things that I want to control. So I'm more on the data cleaning side, spending a lot of time, and that's not really personal. That's more professional.
But
From a personal standpoint, do you want to give, like that makes you stop and think, if I'm signing up for a new service or I'm sharing data for whatever reason with a vendor, do I need to give them this information?
Yeah.
Is that pertinent to what they need to do? Do I trust them to handle it for that exact reason?
That's like when back in the 90s when they started collecting your name and number at the store. Or like
Oh, and they
retail
still
stores.
do. Yeah, give me your phone number. What?
I worked in stores then though, and when we first started asking people for their name and stuff, they're like, "Why do you need that?"
That's right.
For our mailing letter. No.
Yeah, and why at Hobby Lobby do I need to give you my phone number? So it's 555-1212. Yeah. No, I think there's a lot. In terms of like, all right, let's go to something that everybody can relate to, which is you're prompting something to write. Now, we're not talking about anything for a lawyer perspective, nothing for you as a CEO. So this is personal, so we don't want to get you in trouble. But if you had to write something just for maybe a nonprofit you're working with, and you knew a little bit about what you needed to, but you want to make it a little bit more informative or whatever it is, would you start with ChatGPT? Would you use it secondary? How do you use it in a responsible way?
I have two different ways.
I can see Franklin doesn't want to answer this one.
Oh, I'm happy to.
Okay, good. Go ahead.
So I'll use it to do a rough draft.
Okay.
On
So the starting point?
topic. Yeah, I'll use it as a starting point in some cases, but then if it's something that I know, like industry stuff, I'll have a rough draft to start with. And then like a descriptive rough draft.
Okay.
With bulleted items and stuff. And then I'll just say, write something with each one of these points as a sentence.
Nice.
And then that's where I'll start. And
Okay.
it gets me a lot further pretty quick because I'm really good at list making. I'm really bad at like the full editing and stuff like that.
I hear you on that one. I'm that way too. I will put it in and let it be my editor. Yeah. What about you, Franklin?
So I do subscribe to OpenAI's ChatGPT. And so I use ChatGPT 4, and I use it for ideation. I use it to outline. I use it to help improve my writing. This is all personal. This is all my personal capacity. I
understood.
do all that.
Yeah.
And I mean that seriously. I'm not joking in that sense. From my employer standpoint, depending on which employer I'm talking about, I let them, they're the ones that have the policies that dictate
for
that.
sure.
So I respect that. But for my own personal capacity, if I'm writing something, I use it for ideation. I think it's also helpful just to make sure I don't miss anything. And it's helpful to improve my writing. If I want it to help, like say, how do you write this more persuasively?
Yep.
I personally disagree. I don't ever copy and paste straight from what's presented.
Absolutely.
That's just my own personal viewpoint on it, my own personal ethical consideration there, especially because like I do a lot of freelance writing for news publications. And so for me, it's like what I write, I want to be my own.
Yeah.
And then I can't help but also put my lawyer hat on because anything that is synthetic in that sense is not copyrightable. The Copyright Office in the U.S., at least, and other parts of the world, it's come out to be said as well. Human authorship has always been a fundamental foundational requirement for copyright ownership and being able to register it with the Copyright Office. So that basically takes you out of the ballgame of being able to claim ownership and protect what you're putting out there or sue others for what you're putting out there.
So what if 99% of it's yours? What if 90% is yours?
So again, that
Again, 80%. Like, where's going to be the cutoff?
yeah, and I actually wrote an article about this.
right.
So
Make sure we get that.
I'll make sure that's in the show notes. Yeah. It's this, I put together what I call the spectrum of creativity generation. It's the creativity generation spectrum. And so on the far left-hand side of the spectrum, you have just me talking out loud at a conference, not even a conference because that has like technology involved, just talking to a group of people, delivering a speech. Performing on a stage where I am dancing and not that I dance, but you get the point. That
will be in the show notes.
Yes, I'll send you that. So that is that's creation without any tools. That's creation without any assistance. And then you can the spectrum continues along where, okay, you're using a paintbrush, or you're using a microphone system, or you're using sound recording equipment, or you're using a video editor, or you're using other tools like that. And the progression can go where, okay, it's human authorship that's being assisted by a tool, or photography. That's one of the bigger questions right now in the Gen AI space is people are pointing back to when photography first came around, because copyright was around before cameras came around. And so it originally, there was no such thing as photograph, so it wasn't a part of Copyright Act. So the development of copyright around the advent and invention of the camera is huge influence for a lot of people in trying to apply existing copyright laws and protections to generative AI. So anyways, the spectrum continues along, and then you kind of hit this middle ground where, okay, I'm using Word, I'm using spell check, or I'm using this. When I first created this, Copilot was not even publicly accessible. OpenAI was not really out yet. So it's this concept of, okay, I'm using Word where it will almost complete my sentence, or it has grammar check, or I'm using a developer environment of some kind where it will complete my code, but it won't do it to a sense like it's writing out the rest of it for you.
Sure.
It's just guessing what the next phrase you might say is.
It's limited support.
Exactly. So that would probably rise to the level of, unless you just do that over and over, which you're just going to get gibberish, because that's not Gen AI. That's just basic machine learning and predictability models. That's where like the Copyright Office would say, like, well, that's not going to knock you out of being copyrightable because you use Grammarly. And that's where I think the AI-powered version of Grammarly, it kind of gets you into the weeds. Well, how much is it changing your writing style?
Yeah, that's a good point.
And so then you continue along the spectrum, and you get to this phase where the Copyright Office has said outputs from Midjourney are not eligible for copyright protection because there's no control. Even if you're prompting 500 times to get to a specific output, it's a black box of what happens with the model and the software that you're using. So that takes away that human layer of control. And they've even been challenged on it in recent cases, like the artist, I use air quotes there, but the artist that submitted the work, Space Opera Theater, to the State Fair and won. There was like a New York Times article about it, and he won the prize. Came out later that it was generative AI. He actually used Photoshop, and he also used another AI tool to upscale the image from, I think it was Midjourney that he used. So there was a more creative involvement, arguably, but the Copyright Office still said, no, the underlying image is this thing called the de minimis test. Sorry, a long-winded way of getting to your point of what the Copyright Office has recognized as what's called the de minimis test. Is there how much of, it's kind of basically the best way to put it is, how much of the final work product is human authored, and how much is machine generated or synthetic content. And I point to all this because, again, we're talking about creativity. This is hugely important if you're working in an IDE. If you're working in integrated developer environment. So like if you're using GitHub that plugs into why am I blanking on? Like Microsoft has one, Apple has one, Jupyter, and if you're using something like that,
A compiler? Is that what you call it? No?
Is
Or a library? I don't know. I don't know development.
It's basically the space where you're writing the code.
Yes, I am doing a terrible job of remembering what they're actually called.
You let that part for me. Great job, though.
Apple has one, Microsoft has one. Anyways, so that's what I beg the question of, like, if you're using a Copilot, if you're using a Gen AI tool to develop code, you're calling into question your ability to protect under copyright law that software and the output. Software is still hard to copyright. There are a lot of gotcha moments with it, but there's also the same thing with patent law, though. You can still patent software. And so you might be calling into question, because on the patent side, what patents are covering inventions, copyright is for creative works. With patents, there's also the same issue. You cannot patent something that is not human invention. And so it's this kind of issue where people are trying to patent stuff that has some level of machine invention contribution to the invention. And it's like, well, sorry, says the Copyright Office, or it says the USPTO.
Wow.
What
Okay.
if, like a quick hypothetical, legally?
Hit me.
If I say we had a mid-journey where if I had a 3,000 word prompt that generated the exact same image every single time, would that not be?
Would that actually happen?
I mean, so if it could happen, it can't happen right now for sure.
Right. Yeah.
Actually,
that's
you can,
the reality.
because you can add a random seed to generate the same thing. You can do that in modeling. It's
Without using that same prompt?
No, you
Without
have to
using
use
that
it-
output back and circling back into the
So what I'm
prompt?
saying is, could you potentially like so I'm thinking back to the what's the movie where the dude has the intermittent wipers, A Stroke of Genius?
yeah. Yeah, I know which one you're talking about.
And he talks
I've
about
not seen it.
Well, anyways, he talks about like his they were like, it's just a random like group of electronics that everybody's got access to, and he was like, well, is the something that people can't use? And then he's just like, all this is a random string of words that make sense to people. And so if I create a prompt that's repeatable by anybody else unless they've got this in their hand, is that not something that has value?
So the Copyright Office has said, they held a webinar last year when they first put out their guidance around generative AI,
Okay.
and they have put out guidance on it. I'd recommend if
Okay.
somebody wants to read it, go read it. You can actually go to copyright.gov/AI, and that will take you to their AI landing page, and you can find their guidance, or you can find the Castanova case that I mentioned, and some of the other ones like the state case, the space opera theater one. Back during the webinar they held after they released their guidance, one of the questions was, is a prompt copyrightable?
Yeah. Okay.
And the response from one of the Copyright Office attorneys was, theoretically, I guess, they're not aware of anybody at that time. We're not aware of anybody having attempted to register a prompt. But if it met all the requirements for copyrightability, which is like human authorship, is it human written? Is it creative? Is it written in a tangible medium of expression? So if you're typing it on a computer, then you have. Then arguably you could submit that to the Copyright Office and register it as probably just a textual work. And so in that sense, that might be protectable. But in terms of the system, that kind of gets at the heart of understanding the guidance we have from the Copyright Office right now is basically looking at the fact that a lot of how these deep learning models work is that it is all probability, it's statistical.
Yeah.
You cannot control, at least for now. You can have some guidance on the it depends on really how the software is developed, because some software does allow you to fine tune and have granular controls over how much randomness, noise, all that kind of stuff.
We're talking about general.
Right. General use tools, though, pretty much don't offer that. And the Copyright Office, I think, even pointed to the fact that, like, with some of the tools, you get back 4 different options. That alone is showing that you really have no control over you're selecting from 4 or 5 or however many of the outputs there are. That's your selection as a human, but up until that point, it's all the computer software doing it.
Yeah, you made that comment earlier, though. It's black box technology. Like it might as well be magic as far as the user's concerned, because we don't have any input or control over how it's manipulated once we give it a prompt.
And the developers are finding that too. I think model developers are seeing that too. That's why they do a lot of research and red teaming and all that to understand what is capable with this particular model, or what happens when you put this and build on it or sync it with other technologies, other models. Like, that's where you really get into the nitty gritty of understanding what are the capabilities here. And that's kind of like where it's like this, what's the future going to be? And it's kind of interesting when you get into that sense. But it does, from a standpoint of quickly adopting these tools, stop and think about what you might be losing out on from an IP perspection standpoint, if that's important to you.
Yeah.
Well, that's good. Well, we are at that point.
Yeah,
'Cause
there's
you
so
guys,
much to talk about.
You know, and I think Franklin has just become a regular because this is going to continue to be a topic that I think everybody needs to know about. I know I mentioned that we are having somebody on, like Franklin, to a bunch of executives, and they're like, "Which episode is that going to be?" Because they're wanting to know what the heck to do, as well as the average listener out there as well.
Yeah, and we didn't even get into the creator economy.
No, and I love creator economy,
Yeah.
but we also didn't even touch on like the FTC. You could have a whole episode of like, what is the
absolutely.
FTC? What is the
Write
SEC
that one
doing?
down. That'll be in the near future here. And we stayed away from industries specifically like healthcare, I think for a reason. You know, we stuck to
somewhat
ones
general
that
stuff.
were relatable, which is the creative side, to explain this stuff at least the first time, right? And I think it would be really interesting to get into more operational modeling, like in the manufacturing space, the finance, and the healthcare space. And I think that there'll be some really interesting things there. Franklin, but we don't want to just cut you off. Anything that you'd like to add as a parting shot or plug or anything else?
Don't forget to tell us
Non-lawyery? Yeah.
Yeah, so I predominantly post on LinkedIn. I sometimes cross post to X. I've gotten away from that just because it's hard to pick a platform.
Yeah,
but
I'm with you.
LinkedIn is where I find the most algorithmic favoritism, I guess. I have creator mode turned on there. But so, yeah, find me on LinkedIn. It's pretty easy to find me on any social media platform. I'm Franklin Graves. I also have a newsletter that focuses on issues in creator economy, if that's something you're interested in.
Where would we find that?
Is on LinkedIn.
Okay.
But then I also have a website. And again, I'm terrible at updating my website, but it's creatoreconomylaw.com. Pretty much what I post on LinkedIn and with that newsletter for right now is the same as what's on my
gotcha.
website.
Well,
Yeah, and we'll definitely have those links. Actually, you've already given them to us, so we'll make sure that people get that. Charlie, any last questions?
I've had a blast. Like
Yeah.
I thoroughly enjoy living in the times where we get to make the rules and stuff.
Isn't it cool?
And so it's really neat talking to you about all of the current goings on and stuff like that, like in the actual legal realm, because that's ultimately where this is going to get sorted out.
Right.
Yeah, for sure. Thanks, Franklin, for your time today.
Thank you all for
I knew
having
this
me.
would be a quick hour and a half is what it looks like we are at. And we want to thank all of you for listening here today. We'll thank also the National Technology Council for the space to be able to do this. If you like what you heard, please follow Franklin Graves on LinkedIn, but also go ahead and follow us on your favorite podcast player. That's Data for All, Data, the number 4 and all. And you can find us on our website and all of our videos there, our YouTube channel at dataforall.io. And for the Data for All podcast, I'm Charlie Apigian.
And I'm Charlie Yield.
And until next time.